Dear colleagues, friends and family of our much-loved Professor Burkhard Schafer, it gives me great pleasure to say a few words of introduction before Burkhard delivers his inaugural lecture to us all. In this case, inaugural may be rather stretching things. Burkhard's chair in computational legal theory was conferred upon him in 2010, so we've had the benefit of his professorial wisdom these past 8 years. The fact that we've had to wait 8 years for this happy occasion is in large part, I suspect, a result of Burkhard's terrible affliction. He is a workaholic, regularly to be found at his desk at the crack of dawn or late at night in the service of his students, colleagues, and the wider academy. In a life as busy as Burkhard's, finding the space to write an inaugural address must have seemed a self-indulgent luxury. Burkhard's legendary work ethic is such that I sometimes wonder whether he hasn't managed to clone himself. Such is his energy and productivity, it does often feel like there are two of him running around. Whether he may indeed have a clone, we don't know for sure, but I'm happy to confirm that we certainly have the original Burkhard with us here this evening. Burkhard, as some of you may have gathered, is not originally from these here parts. He is one of the happily growing band of wonderful international colleagues that so enrich the life and culture of our law school, and will, I am certain, continue to do so, whatever the trials and perils of the process of Brexit. Burkhard hails originally from the picturesque town of Wiesbaden in Germany, known to some perhaps from the amusing fictional tales of Professor Dr. von Egelfeld, penned by our former colleague Sandy McCall-Smith. Burkhard's non-fictional academic career stretches as far back as 1991, when he was appointed as a tutor in logic in the Department of Philosophy of the Johannes Gutenberg University in Mainz. Luckily, Burkhard was not lost to the fiendish logicians for long, as having migrated to Lancashire in 1995, where he briefly taught at the University of Lancaster, he was soon poached by us here in Old Reekie, joining the Edinburgh Law School as a lecturer in 1996. He was promoted to senior lecturer in 2004, before very fittingly being made our chair of computational legal theory in 2010. Computational legal theory is, so my computer tells me, the exposition and formalization of legal theoretical issues for the purpose of computation and automation, though my computer's probably got that entirely wrong. Burkhard is undoubtedly at the cutting edge of the university's teaching and research of law and robotics, of information technology law, and of AI's impact on law and legal theory. He's been the recipient of numerous academic grants and awards, and is a board or committee member of a string of learned societies. He's playing a leading role in the law school's engagement with the Edinburgh Futures Institute, where he is demonstrating his flair for cross-cutting interdisciplinary academic engagement. Burkhard's published research is, unlike my own, in exciting fields. His publications are deeply impressive in scope and reach, ranging from contributions to the fields of online legal education, legal information systems, epistemology and legal regulation of proof, theories of evidentiary reasoning about motives, statutory interpretation, data protection and confidentiality, privacy, autonomous vehicles, robotics, and artificial intelligence, amongst others. He has a knack for engaging the reader of his work with apposite quotations from fiction, poetry, and song, and references to sci-fi and popular culture. This makes his work not only scholarly and illuminating, but also fun to read. His scholarly reputation is immense, and he is frequently sought after as a co-author both here and abroad. Writing alone or with co-authors, he is published in English, German, Italian, and somehow in Latvian too. Feel free to test him on his knowledge of these various languages after his lecture. Burkhard is an exceptional colleague. He is one of the most dedicated and collegiate academics I've ever met. Moreover, he possesses that rare academic quality, a sense of humor, and not just a German one. He is passionate about his students and their education. Best of all, he is a dean's delight. He never says no to any request of mine, a trait which I suspect he sometimes regrets. So indispensable is he to what we do in the law school that we didn't even let him go on his sabbatical this session, making him wait until next session for a very much deserved break. It's hard to imagine an Edinburgh Law School without Burkhard. Happily, we need not even contemplate such a horrible prospect this evening. It's a great pleasure for me to invite Burkhard to deliver what I am sure will be a characteristically engaging and inspiring lecture. The title, as you can see, is Who Needs Flesh and Blood E-Lawyers, Legal AI, Rule Following and Computational Creativity. Burkhard, over to you.
Thanks a lot. Yeah, thanks a lot, Martin, for these very kind words. Starting a inaugural with a little bit of reflection and reminiscing is, I think, quite appropriate. And you already mentioned my somewhat long journey that I had to take in order to get here. Starting out in 1996, leaving Munich, where I did my undergraduate degree, as you mentioned, to arrive in Scotland. Now, Scotland and Bavaria have more in common than simply the white and blue of our flags. We also have this one in common. In case you don't know this man, that is Franz von Bayern, the Prince of Bavaria, who is also the head of the House of Stuart. So for a dyed-in-the-wool Jacobite like myself, probably my lawful sovereign. And with other words, the immigration from Bavaria to Scotland wasn't that big a deal for myself. It was really just moving from the southernmost region of the Stuart Empire to the heart of the Stuart Empire, and with that actually coming home. And despite all the disciplinary boundaries that I crossed, it also felt, amazingly enough, intellectually like coming home. Because I don't think that at the time there would have been anywhere else in Europe a place that would have been as welcoming and as accommodating of people who cross intellectual borders. I ended up in a Center for Law and Society where Neil McCormick would combine political theory with legal reasoning, Zenon would combine theological thinking with legal doctrine, Leslie would combine system theory with criminology. So all of us, in many, many ways, were crossing already then the boundaries between the disciplines, and I immediately was felt welcome, at least once my interview had been over. Now, the interview had been slightly more unusual, and I must admit I didn't, at that time, put much hopes in getting that job. I mean, being a essentially philosopher with just an MA in philosophy, applying at a law school, and the interview didn't help because one of the interviewees started to mutter under his breath while I was talking, "Death, death, death." And I sincerely felt that at that point I probably had lost my audience. Another member of the interview committee tried to balance on the back two legs of his chair, precariously waving his glasses over his head. And I thought, okay, if I kill Neil McCormick while doing my job interview, that probably also doesn't bode particularly well for getting accepted in this law school. And indeed, I didn't, at least initially, get the job, and then was phoned up after something unfortunate and inexplicable had happened to the other three candidates who were originally listed higher than me, and there suddenly was this job opening. So I got a telephone call from someone who talked to me in German, but only by quoting Goethe. And eventually I figured out this was actually a job offering. So that worked out all fine. I finally arrived here in Edinburgh, and I was immediately given, as part of this very warm welcome that I received, the two most important, most significant jobs that this law school, at least the Center for Law and Society, could give on someone. Great honors that I try to be worthy of ever since. So I became the keeper of the eternal urn of the Center for Law and Society. And I've been using it for making coffee for my students for these past 21 years. I did a very quick calculation while in my office. I think I watered with this urn around 900 students over the years, making 2,500 liters of water in the process. And Center for Law and Society lore has it that the moment this urn will ever be empty and without water, terrible things will happen to us. So I always made sure that the water was topped up. And then I thought about this. Because I always topped up the water, there's at least a certain statistical chance that there are still some water molecules in there from the original water when I took it over 21 years ago. And at least there will be water molecules in it that no water molecules that were in there when I took it over. And some of the students in my audience might now wonder whether it was a really wise decision to have that coffee earlier on. But traditions are obviously very, very important. And if water has memory, then this urn has the memory of 20 years of legal philosophy in Edinburgh. This was not the only important role I got. I'm not only the keeper of the eternal urn, I'm also a guardian of another important token. I'm slightly more hesitant displaying that one because my godfather is in the audience today, and he was a professor for anatomy, and one of his roles was to lead the anatomical museum in ways that are ethically and legally responsible. And I'm not totally sure if this next item meets his approval, but in addition to being the keeper of the eternal urn, I'm also guardian of the law school skull. That one I inherited when we found it in a cupboard in a box when I arrived, and because I was teaching forensics at that time, it was deemed appropriate that I was going to keep it and treasure it. I did mention that something terrible happened to the 3 people that were in the appointment list higher up than me, didn't I? So this skull has played an important role in my teaching ever since. It reconstructed lots of crime scenes that we investigated with our students. It was used as a teaching aid to explain to students the concept of post-mortem privacy, and it also was used to elucidate very, very complex notions of concepts, the extended mind, the role that our brains play in our cognition. So he really did play a significant part of our teaching. And there's a more significant point in this, to which I will come back later on. This skull was used by a professor for forensic science long before I came to Edinburgh, but using things that you can touch and see, physical objects, material objects, rather than just books and text, is one of the things that we very often overlook in a law curriculum. Unlike many other disciplines, we do not normally deal with physical material objects. And I think that's a problem for our teaching, and we will see a little bit about that later in the course. So that was my physical, my geographical migration, but there was also, I think, a journey in terms of the development of my subject. When I arrived in Edinburgh, I would say Edinburgh was one of only maybe 3 law schools in Europe, and definitely the only one in the UK that was offering AI and law as part of the curriculum. By now, you would find probably 20, 25. It has become mainstream. You find job advertisements pretty much all the time. And when I started, we had 2 weeks in the honors course in legal concepts dealing with law and robotics, and we had typically 8 students for that, together with 1 LLM course, Risk, AI, and Legal Reasoning, again with typically 8 students. Now, we have 1 dedicated honors course, always oversubscribed with 28 students, and we have 4 LLM courses in that field. I think Edinburgh is still leading in providing law and AI teaching because of that, all of them with more than 33 students. Now, I would, of course, love to take all the credit for that, and that it was just me who pushed AI and law so much in the mainstream, but that would probably over-egging it just a little bit, because one event in recent time played a significant role to put something that was very much a niche subject into the mainstream, and that was Alphago, and the first time seen by hundreds of millions of people all through the world, seeing AI beat a human Go master in that game. And the reason that this was so significant had to do with the nature of the game of Go, which, according to its cultural significance, in China, Go is not just a game. It is also a mirror on life. We say if you have a problem with your game, maybe you also have a problem with your life. So on that basis, once a computer masters Go, then we should expect a computer also to master life. And that is, I think, part of the mistake that quite a lot of people had made the moment that result came out. And we will have to come back to the truth of that statement later on, because it will have quite a significance of how we see the future of our discipline evolving. I will try to analyze a little bit the interaction between law, creativity, and rule following using some quotes that were made by observers of that game. Whenever that happens, you will find in the left border corner that Go game. So I will use this game to illustrate a little bit some of the issues that form part of my research. What was the reaction to Alphago winning? Well, a sudden fear of technological unemployment. When robots can play Go, then they can play everything, and they can also take out our jobs. So we get suddenly a significant concern that the fourth industrial revolution is over, and we humans, we lost. Robots suddenly not only capable of performing physical labor, but performing intellectual tasks that previously had been seen as the sole response of human beings. And that didn't stop at office jobs or manufacturing jobs. For the first time, this also became seen as a threat for intellectual disciplines, for the professions, including the law. And we get headlines like that. Law firms hiring a lawyer named Ross. Introspection, preventive law with AI. Richard Susskind announcing the end of lawyers. And another one, meet Peter, UAI-based legal advisor. Lawyers could be the next profession to be replaced by computers, said CNN. And according to the Law Society, not only did the peak employment already bottom out back in 2009, but because of the increased use of computer technology, we will not recover previous levels of employment in the legal profession. So according to the analysis of the Law Society, the threat of computer technology, the increasing use of AI, will mean for the foreseeable future a significant reduction in the labor market for law graduates. That at a time where interest in law as a degree is booming like never before. You might have seen last week the numbers of mega law schools taking in more than 500 students in their first year intake. So we find a little bit of a paradox. On the one hand, even the legal profession recognizing that there might not be a lot of work to do for lawyers, if their prediction is right. At the same time, increasingly an interest in law as a degree program. So, what can we do? I think as educators, as universities, we have to rethink what it means to be a professional. We have to rethink what it means to be a professional lawyer, and we have to prepare our students as best as we can for that environment, for that world, where they will have to compete not just against each other, but also increasingly against technology. And in order to do that, we need to reflect what it means to be a lawyer, what the values are, what we can add to the life of our clients. And we also have to ask ourselves what the things are that makes us genuinely human, those things where robots are bad at competing. So where can humans beat machines? Amazingly enough, things like dancing and ballet. Robots are rather bad at that. I don't know if you ever saw a robot dance. There's one who is reasonably good, but it is still relatively primitive in comparison to the best dancers. So physical dexterity and mobility, that is one of the things that if we train them, people will have for the foreseeable future a significant advantage over machines. But as I said before, as lawyers, we very often think that there is nothing beyond text, and that the only thing we have to do in order to train lawyers is to make them read and analyze information, things computers are notoriously good at. Now, Edinburgh always was in the forefront of challenging this assumption and finding out that it might actually be quite significant to teach lawyers an understanding of their own body and to integrate physical interaction and being a lawyer and conveying information or knowledge or insights in that different way. I was only involved at the margins of this project that was at the time run by Xenon, but we built a small project on the back of it together with the Mexican judiciary, Mexico is in the process of changing from a rule-based system, which is very rigid and doesn't particularly cherish creativity, to a case-based reasoning system along the American lines, UK lines. And we thought, how can we use this notion that we have to go beyond text to assist Mexicans in that task? There's another way, and that was our take, in which law could be physical. In a long time ago, the typical way of solving a legal dispute was through trial by combat. This is one of the first recorded ones in our legal history. I have to use my script sheet here very, very briefly. Oops, or rather not. The guy on the left is an Anglo-Saxon, the guy on the right is a Norman. So in this picture, we also see a class conflict, one of the first times in which one of the vanquished nation tries in a legal context to challenge one of the victors. But this was a legitimate way to settle a conflict. And it was, of course, highly ritualized. And I'm saying something briefly here because it will matter later on. By turning a combat into a trial, by giving it rules, what it also meant was to de-accelerate the timing of the conflict. Where in the past, if you wronged me, if you stole my cattle, I would simply take as many of my guys as I could and immediately get over to you and get it back. Now, the French came, 1066 and all that, and they had bloody rules for that. They had lawyers, and suddenly you had to fill in forms. Is that a regulation sort? Oh, no, that's a little bit too long. Do a health and safety assessment first. And by the time you went through all that material, you probably had forgotten what your conflict was about in the first place, and you were willing to give up on it. So sometimes being slow and giving people time to think is the right thing to manage their conflicts. And we have to come back to that later on, because one of the things computers are doing is accelerating the speed of dispute resolution, the speed of decision-making further and further, and I think with that undercutting that civilizational tendency. Hector McQueen wrote about trial by combat in Scots law, and if I understand Hector's analysis correctly, then it is still competent under Scots law to challenge someone to trial by duel in defamation cases, because this is a common law right that was never officially abolished through statute and therefore survives. So one of the ways we might want to train our students in a more physical way to be prepared for the future is to give them basic lessons in swordsmanship. I don't know if you know that battle, or rather that trial. It's again a trial setting. It is the last trial that was decided on UK soil through the wager of battle, so not through one-to-one combat, but through entire groups of fighters. It was fought in Perth, a few miles further up to the north. The legal issue at hand was which of two clans was the more preeminent one according to the rules of chivalry, and therefore had the right to fight in a real battle, in a real war, on the right-hand side of the king. And in order to sort out that important question, they had a sort of mock battle between 30 of each clan. One of the clans had one person short. They only had 29, so they hired a bystander who was willing for money to fight for them, and we have a prototypical lawyer here, someone willing to fight, risk their life on behalf of their client. The Battle of Perth could be deemed to be a little bit of a backfire, because at the end of the day, only one of the fighters had survived, which meant the army of the king was now so depleted that the war had to be cancelled anyway. So there's a certain efficiency argument to be made here that this type of dispute settlement mightn't be the best way to go. Now, we took our inspiration from that because we thought one of the things you do in law, you very often use military metaphors, at least, to explain to students or to your audience what it means to be a lawyer. We get the dueling cannons, sorry about the pun, by Carl Llewellyn, or we get from Yering the fight for law, one of his, I think it was his inaugural lecture, where he described the importance of law with that of a fight. So long as a law is compelled to hold itself in readiness to resist the attacks of wrong, and this it will be compelled to do until the end of time, it cannot dispense with war. War and law are inseparable. And if law and war are inseparable, then we might be able to use methods to teach war, and which go beyond text, also as methods to use to teach the law. Now, you will all have seen cards like that. That is obviously the Battle of Bannockburn, Scottish victory, in case anyone was wondering. I've chosen my cases, yay, freedom! I've chosen my cases very, very carefully. Famous Scottish victory of Robert the Bruce over Edward. And the important thing here is, this is still something that is used these days to teach officers, for instance, about the dynamic of a battle, using specific types of visualization to get across where the center of gravity is, how to lead an attack, what can go wrong and what can go right. So what we did in this project was to combine a traditional reasoning system, the hypo case-based reasoning system developed by Kevin Ashley in Pittsburgh, but rather than using boring diagrams, arrows, and boxes and a lot of text, we turned that into a battle. This is a famous case from the US, Casey against the US. It's about siege and search and seizure law. What used to be battalions are now precedents. And what used to be fortification movements are now statutes. So we translate essentially the symbolic imagery of war and battle into that of leading a case. Here, a hypothetical is used to test out the strengths of the opposing party, to tease out if their precedents are quite as strong as they seem to be. Unfortunately, the defense falls for that precedent. It overextends itself. It makes an argument that ultimately is too strong to be sustained, and they probably get wiped out in that case. So that was one of the first ideas or first approaches where we used computer science and AI to use an existing system, a case-based, traditional argumentation-based system, added the imagery of battle depiction to find a way to teach lawyers to think outside the box, to move beyond the textual information to something that allows them a more intuitive and a more creative understanding of what it is that they are doing. There are other things where humans beat machines, and I will focus today and in the rest of this talk primarily on the first one, the issue of creativity. Creativity and rule following is one of these oppositions that can tease out and make us reflect about the limits of law and the nature of legal reasoning. In the same way in which Zenon used the computer metaphor to think about love and computers, and others have thought about the computer metaphor to think about legality and legitimacy as the universal and the particular, we find the same type of tension when we think about creativity and spontaneity in decision-making and the strict rule-following and observing of past knowledge. The creative problem-solving area of concentration is designed to help you acquire the needed skill that demand broader and deeper understanding of people, their problems, and the consequences of confronting those problems only in narrow, legalistic ways. So California Western Law School, some of our competitors essentially arguing there is one way of doing law which is narrow, legalistic, formalistic, and that will be the part of law that will be replaced by computers, but we are able to train you, we are able to tell you how to be creative in legal problem solving. Here from an advert of one of the leading IP law firms, XYZ hires passionate, determined people and empowers creativity that delivers innovation to the legal and IP market. So increasingly, those law firms and law firms and law departments recognize the value of creativity, using that as a unique selling point to say we can imbue our students with resistance against automation, because by definition, computers will only ever be able to deal with rule following and non-creative tasks. We, on the other hand, will be able to teach them creativity. But what does it mean to be creative as a lawyer? What do we mean when we say we teach our students creative problem solving? Is it like creative bookkeeping? You know, hard at the borderline of the rules, slightly dodgy, not totally honest, but also not so far pushing it that we commit a crime. Is creative lawyering the same as creative bookkeeping and playing with the numbers? Or is it something like that, the Chewbacca defense? It just doesn't make sense. bamboozling a jury with a random comment thrown at them, breaking the rules, or not quite breaking the rules, being most certainly creative, but at the same time, I think lots of people will feel that this is not what we should mean when we say we teach our students creative problem solving. We should mean something else. We should mean we teach them to observe the highest standards of the legal profession, the ethical standards of the legal profession, and nonetheless allow them to be creative. So there shouldn't be a tension, I would hope, between creativity and ethical behavior, professional behavior. And yet, at least one way of thinking about creativity in the law is doing exactly that. It's identifying it with playing hard and fast with the rules and pushing them to their very limits. So my question, the question of my chair is, what can AI teach us about creativity in law and legal education? What does it mean actually when we say we teach creative problem solving? And also, what type of legal AI should we build? Is it AI that helps us to be more creative? Is it AI that deals only with the boring and mundane jobs while allowing us to be more creative? Or should we build creative AI? And what would that actually mean? And at the end of that, hopefully, we will have an understanding of what it means to be good in our profession, creative and yet professional, innovative and yet ethical. Now, one of the things I learned when I came to the UK, one of the readjustments I had to make being trained in a continental jurisdiction was, of course, to rediscover the importance of history. The difference between a legal system that had created an artificial break from its past and said nothing before 1900 matters, because that is when the civil codes are enacted, to a legal system where the past is always present and where it is always possible to go back and draw from the experience of past generations for problem solving. So one form of creativity, obviously, is to find something that had been around before, even if it was in a different guise, maybe, and reinvent it, reuse it for current purposes. One of the things that really struck me when I started teaching together with George Gretton, German law, was, I think, and I hope I remember that correctly, that you once succeeded in quoting an actual case from the Roman Republic. So going beyond even the pandectists and very creatively finding a case that everyone else had overlooked. Now that was a challenge. Going back to the Roman Republic, that's quite cool. So I thought, let's see if we can go further back, because I want to convince you that law and AI and law robotics is actually even older than the Roman Republic. Law and AI was there truly right at the very beginning. The first robot ever was built by a lawyer. If only I had my notes ready now. I really wanted to give you that quote, and I'm not going to get it verbatim. Yeah, there it is. Sorry about that. That is the golem of the Jewish law. And in the Tractat Sanhedrin of 65b, it describes how the first golem was created. And the Tractat Sanhedrin, of course, is the case and materials of rabbinic law. That's what it is. It is a textbook that gives you cases and the material. And one of the most important, the most perfect legal scholars of his time, Amora Rava, a 3rd century BC lawyer, was the one who allegedly was capable of creating the first golem. He was the most respected member of the legal profession. He made a massive contribution to doctrinal law. He developed the rabbinic law of good faith acquisition, and he developed the rabbinic law of witness analysis, and he also built the first golem. And within the Jewish conceptual philosophical system, that makes perfect sense if you remember Genesis 1. At the beginning was the law, the logos. So God is logos, and perfect law is also a creator. By being perfect law, God is capable to create. So someone who is almost perfect as a lawyer, as that Rabbi was, should be able to create almost something that is a living being, that is the golem. I say almost because the golem also suffered immediately an abysmal fail in what we would call today the Turing test. It was ordered to go to another famous rabbi and do some chores for him. The golem did that, followed the rules to the letter, because it is uncreative and can't do but following the rules. But when that other rabbi asked him a question, what are you and why are you here, it couldn't answer. Because even though it could follow the rules, it couldn't explain why it was following the rules. It had no understanding of what was driving it. It had no understanding of its own motivations and an understanding of its own destination. And the moment the robot failed the Turing test, immediately became visible as just a human-made thing. Rabbi Zera said, "You were created by the sages, return to your dust." And it crumbled and fell back into the dust. Now, I'm not suggesting that we are using this as an examination method for our students. It is tempting. You are wanting to be perfect at law, try to create a living being. Let's see how far we get with that. That might be a little bit too much, but we find this notion that there is rule following and understanding that you are rule following at the very beginning where robotics start. And if you followed the current discussion about legal AI, about expert systems, the question, can they account for their own reasoning? Are they a black box? Are we moving towards a black box society? Is as pressing today as it was then 300 years before Christ. And the question, is it good enough to follow rules? That's easy to do, or comparatively easy. Even an imperfect maker achieves that. Or can we build AIs that account for the reasons that they follow it? And that obviously is one of the great challenges generally of using AI in decision making. So the Turing test was an epic fail, but robots perceived being dangerous is something that pops up in the mythology of various people throughout the centuries. We get Hephaestus, the smith and engineer of the gods, building Pandora, a robot that comes to mankind and obviously opened Pandora's box, bringing disaster. She is designed, she is a robot. We get in Christianity the myth of Adam and Eve being created and leading to the downfall, to the fall by convincing man to eat an apple. Now, obviously, Eve is not technically speaking a robot and designed. She is bioengineered. Therefore, she falls in the responsibility of the Mason Institute colleagues rather than script. But I always felt that there was a very, very strong affinity between Mason and script, and obviously a shared history. So I might be forgiven once again for transgressing disciplinary boundaries and talk about cloning rather than merely robot engineering. And if you think this was just expressing a myth of people back in the past, think of today and Ava in Lex Machina. And obviously the common theme that we immediately see here is that in societies where women actually have next to no power, they somehow still end up as the bad person when it comes to robotics. The robot female as the ultimate destroyer of mankind, both in the old myth and in the new myth. And just to illustrate even more how far away that is from reality, think about the AI that we are actually using. We get, on the one hand, a law firm, Ross, obviously a man, and then we get assistants like Siri and Tay, who are as obviously female. So on the one hand, we project all our fears into female robots, but as soon as we use them, we fall back to existing stereotypes about appropriate gender roles. And we'll come back to that hopefully a little bit later, but this is just to highlighting one of the challenges that we face in the field of ethical robotics and legally appropriate robotics, discrimination law, equality law. We definitely have a big boys problem in Silicon Valley, and our AIs at the moment tend to amplify and repeat past traditional conceptions that go back 300 years and more in our history and talk to these old fears. Recurrent themes. Legal AI is perfect rule following. It follows the rules. It is not creative. It is therefore predictable. It is willfully non-creative. That is how the original golem was found out. It is bad as natural language processing. Tay felt in its ability to talk to people when she was deluded by other users to adopt rather racist attitudes. In the same way, the original golem felt the Turing test in its ability to speak. A knowledge acquisition bottleneck, it takes a lot of time to train them up. And then we get the golem and the myth of the golem, which you might remember from the 16th century. Here we get something that is created as a protector of the people. We get a people that is under oppression, the Jewish community in the predominant Christian countries. They are yearning for a deliverer, someone who protects them. And they go back to what is natural to them, something that follows the rules strictly. The golem is their machine, it is their protector, and is built to follow the rules and nothing else. And as you know from the story, that backfires badly, because the robot or the golem doesn't understand the context of its actions, and the moment it is confronted with a situation it was not designed for, that was not anticipated by its makers, it runs amok. Trying to protect the community, it inflicts tremendous harm on it because it doesn't really understand what it is doing. It just works through the rule system that is there. So I think here again we find this ambiguity of following the rules as a form of protection against arbitrary power. The problem of the Jewish community was arbitrary power by the powerful. The absence of law, the absence of rules. Therefore, their hope into something that followed the rules and nothing but the rules, and nonetheless ultimately just getting foiled by it and ultimately destroyed. But in societies and also the Enlightenment, where you have huge social upheaval, where you can't trust the authorities, where arbitrariness is increasingly also perceived as a problem, this notion of rule following as a form of redemption becomes even more prevalent. We get the Clockwork Universe by Newton. Dealing with the environment is not any longer a personal issue of pleading. You don't plead with thunderstorms. It follows the rules. The rules might be brutal, you might be hit by lightning, but it is not any longer anyone's fault, also not your fault. It is not you are a bad person, you were not good enough in your prayer. These are simply the rules, and the rules must be followed. So in that notion of a Clockwork Universe, we find on the one hand a form of redemption from arbitrary power. There are rules that govern it, but at the same time also recognition of the brutality and the mercilessness of these rules. We find very early on this idea being transposed to biological entities. This is the famous digesting duck. It was a mechanical device built in the 17th century. It was extremely expensive, a very, very complex clockwork mechanism running on steam. It was able to quack. It was able to eat food and apparently able to digest it, but that was a little bit cheating because in reality there was already a lot of fecal matter placed inside the duck, and if you then pushed something through the snout, it would actually start to defecate. One of the most elaborate mechanical devices ever built, the builder thought that this was a correct model of life, following a mechanical, totally deterministic form. And obviously, people immediately thought, well, hang on a second, what do we have here? It's extremely expensive, it talks a lot, it runs on hot air, and it is full of shit. So, building lawyers should actually know quite easy, doesn't it? We just have to scale this model. And indeed, immediately we get this notion that once we were able to build that sort of machinery, we were also able to replace ourselves or lawyers by machines. Julien Le Dametri, in his book Man as Machine, said, to be like a machine, to distinguish right or wrong like blue from yellow. That is epitomizes the mechanical model of the emerging jurisprudence. This is a question that is just like the Clockwork Universe, totally determined by unmovable rules. There is no difference between right and wrong and blue and yellow. Once we have these rules correctly and we can execute them, all our problems will be gone. All arbitrariness will disappear. All power will disappear. In the same way in which the old gods disappeared from the world, now we can make judges and kings and legislators disappear because it will be a purely mechanical question of strict rule following that absolves us also from that terrible responsibility of being free. So we get this notion of the 18th century mechanical jurisprudence, conceptual jurisprudence, turning ourselves into robots. Fast forward to the 20th century. The historical part is over, you can relax now. But as I said, I think it is important to remember sometimes our rules. The thing that struck me playing through the game, you couldn't tell who was a human and who was a computer. With a lot of software, you find the computer makes a lot of sensible moves and suddenly loses a plot. But here you couldn't tell which was which. That is essentially, again, the idea of the golem. It worked perfectly well when it was used under conditions that its users had anticipated. But by following the rules in different contexts, it started to create havoc. We call this in informatic circles the robustness problem of AI. And traditionally, quite a lot of AI was also affected by it. And that was a bit of a puzzle, because on the one hand, these are just rule-based systems, so they should be perfectly predictable. We should always know what they are doing. They shouldn't suddenly deviate from the script. But because the variance of the environment, in reality, this looks a little bit different. So one of the things I made earlier, Schafer and Bromby, something we studied, developed as part of the Joseph Bell Center that we founded together with Colin Aitken here from mathematics back in 2000, I think, something like that. One of the first systems that we built was an expert system that analyzes the credibility of eyewitnesses. So we have the insights, the empirical data, that given the same characteristics of an eyewitness, different people come to vastly different assessments about their credibility. Jurors, judges, lay people, they all disagree massively whom to trust. As lawyers, we try to mitigate this by something like the Turnbull rules. So we give people rules which we think will constrain their behavior. But despite these rules, we realize or we find that there's still a significant degree of variance when they start making decisions and analyzing people. So what we did was essentially build a very simple system based on a Prolog shell at the time that encapsulated the knowledge that the law prescribes when we evaluate the credibility of an eyewitness, the Turnbull rules, essentially to achieve that level of consistency, using consistency as one of the hallmarks of a good AI system. So in that sense, again, willfully non-creative. Creativity or outliers are the problem. AI helps us to constrain them. That is how the system would look in practice. You get a couple of questions. How far were you away from the crime? How long did you see the crime? Did you know the victim or the perpetrator previously? A couple of known factors that influence our recall, and we essentially tried to encapsulate that in our system. Works well, just like the golem, for those applications for which it is intended. But we used it for a slightly more unusual application. We tested Advocate for Rashomon. Rashomon, one of the most famous movies of the great Japanese filmmaker Kurosawa. It depicts a trial. During that trial, a bandit is accused of rape and murder, and we get the witnesses to that crime. The victim, an observer, the perpetrator himself, his accomplice, and they all tell a totally different story. Even though they are witnesses to the same event, their evaluation differs, or the recounting of that story differs dramatically. At the end, they have a surprise witness. The surprise witness is the deceased, and he is or she is called the ghost here through an occult mechanism. Now, dead people are under Scots law not compellable to give evidence for probably quite good reasons. We do not trust them. There's at least one case where I think a jury decision was finally overturned when one of the jurors admitted that they had been using a Ouija board in the jury room to guide their deliberations. But we should hope that a good expert system tells us that the ghost is probably the least reliable of the witnesses, whereas probably the neutral observer would be the most reliable. Unfortunately, our advocate system failed this test. Advocate is of the opinion that the deceased person was indeed the best witness about their own death, being closest to the event, that factor apparently overriding all of the other factors. And we get the same problem, yeah? Obviously, our system was not designed for this. No sensible person would put it in that sort of context. But that is exactly the problem of AI. If you don't understand its limitations, And if we don't understand that if they are only following rules, we must ensure that the environment remains stable and constant as well, then it will malperform. And that is what I think our analysis showed there as well. In China, Go is not just a game. It is also a mirror on life. I had this quote before. We say if you have a problem with your game, maybe you also have a problem in life. This notion that we can transfer insights from one field of our knowledge to another. If you are, for instance, non-emotional, if you can control yourself well, you'll be good at Go, but that might also be an advantage if you're in a country. So not entering into a Twitter war, for instance, with the head of state of another country that also has nuclear weapons. We might think that this is a type of characteristic that we cherish in a leader, and that type of self-restraint is exactly what Go also teaches you, because you can't play Go in that way. Unfortunately, with AI, it is slightly different. AI still is an idiot savant. You all remember that pain of modern life, an unexpected item in the begging area. As soon as something slightly unexpected, slightly unanticipated happens, very, very often our systems are still bound to collapse. So we are typically, in AI, really, really bad at making that sort of high-level conceptual transfer from one field to the other. Even the best AI that drives a car will be crap at playing Go. An AI that plays Go will be totally useless predicting the sentencing for an offender. They are highly domain-specific. They're extremely good within their domain, but that's about all. Now, what does this mean for us as educators? I would say it means that we should forget about system boundaries. As long as we train specialists, we will train people who are bound to lose out against the competition by machines. Machines are expert systems. They are extremely good at soaking up expertise in very narrow areas and applying it when the prevailing conditions remain constant. They are extremely bad making even the simplest of transfer. So rather than teaching people individual disciplines and training them up with subject knowledge that in the real world anyway never exists in isolation, we should break up also in our education much, much more the boundaries to make our students resilient to the future. Train them against vague problems where you don't know in advance. Do you have a contract law problem, an administrative law problem, an environmental law problem? If you're angry about your neighbor because they discharge their rubbish in your garden, even though they had promised not to do this previously, the client is not going to come to you and say, I have a problem that will be able to be resolved with Article 25 from the environmental ordinances of the City of Edinburgh. They will have a problem, and it will be our part to sort out which problem this is. But that is not how we teach. We teach our students as if they were robots. And with that, we make them compete with robots and with AIs where it is at the strongest. So I think the failure of AI to make high-level conceptual transfer between categories and its exceedingly quality to make highly informed, very, very good judgments in narrow fields of expertise should have profound implications for the way in which we teach. And that is precisely by forgetting about system subject boundaries and their limitations. Creativity is a conceptual transfer. It allows us to see new connections, mosaicing and patent law, bringing different ideas together. That is something AI will still struggle with for the foreseeable future, and we humans are extremely good at it. That's the point of the Go metaphor. Something as different as playing Go and running a country for humans still is somehow the same. For AI, it will never be, or at least won't be in the foreseeable future. Having said that, the competition is not standing still. This is a project we did together with the informatics department of the University of Tallinn. We tried to find out what it means to make a creative, unexpected legal decision. And what we did was to represent the entirety of the Estonian legal system through a connected network, a purely syntactic network, to find connections between terms that are not obvious, that are not something a lawyer would normally spot, especially not if they are trained according to traditional subject boundaries or work within traditional subject boundaries. Take an example. IP law has a provision that gives IP rights to an employer. Employer is, of course, a term that is not genuine to IP law, but a much, much more general term. So what our system would do would find connections between a case decided here, which tangentially changes a little bit the meaning, what it means to be an employer, an employment law case litigated at employment law course, and nonetheless allow us to trace the connection it might have to an IP court and an IP decision. Many of these connections will be spurious. Many of them will not stand up in court. But if they would obviously stand up in court, finding them wouldn't be creative. It is precisely that they are unlikely to be successful, but possibly successful, that we find here an aspect of genuine creativity, the ability to connect things that might just be related and might just allow us to make an interesting analogy, arguing the case of our client in a new and unanticipated way. Traditional current division of labor between lawyers doesn't allow us necessarily to make that connection. If you are working in IP law, you do not necessarily follow all the employment law tribunal cases. You wouldn't simply have the time. Computers can now do this. So at least for that type of creativity, actually, we might even be a step ahead. And that makes it even more pressing, I think, to allow our students to think beyond individual restrictions like that. The one thing that was not human was the way it managed its time. Fanui took longer over its moves than Alphago. One of the advantages of computers are that they are much, much faster than we are. And that is obviously something that also can be tested. There was now a competition between lawyers and an AI. They had to analyze non-disclosure agreements, a team of lawyers versus one AI. And as far as speed was concerned, the AI won tremendously. It took the lawyers between 51 minutes and 156 minutes to work through all these non-disclosure agreements. It took the AI 26 seconds. That means also that it took the lawyers, that's on another slide, which I didn't use, 400 cups of coffee, and the AI not a single one. So also on the coffee count, the AI was vastly superior. So when it comes to speed, we are not going to beat these machines. No chance in hell. If the only difference between the AI and a human lawyer is the speed, the AI will win. If you think of the costs of the legal system, the cost of hiring a lawyer, if you come to the same results, and the AI came also to the same results in terms of correctness, but does the same thing in just 26 seconds, it previously took lawyers lots of billable hours, then the human lawyer will lose out. And that is still one of the main rationales behind quite a lot of the developments in AI as a selling point. Justice delayed is justice denied. Therefore, if we make these machines as fast as possible, then we will also make a reasonable contribution. This is something we developed, Orlando Canato and me. He is now senior legal knowledge engineer, I think, for Pinsent and Mason. And essentially, that system allowed us to speed up the process of drafting Eurobond contracts by a considerable amount of time, being both more reliable and faster. So if we compete against that, if we compete on speed, there is no way that humans will outcompete AI. And that's where creativity comes in, because creativity and speed are negatively correlated. We tested the hypothesis that creative people should show faster reaction times on unambiguous tasks and slower reaction times on ambiguous tasks. The hypothesis was confirmed. There was a negative correlation between creativity and reaction time on an unambiguous concept verification test, and a positive correlation between creativity and negative priming task. If you are creative, you take your time. You suddenly see things no one else was seeing, but only because you were able to say, hang on a second, I want to step back from this problem. I want to get back from the priming I have received. So the willingness to take time, the willingness to deal with ambiguous situations, that is the one where we as humans will still outperform AI for the foreseeable future. So what should we teach? I think we should teach patience. And I think all the teaching reforms that I experienced here in the UK over the past 10 years at least are pushing us in the opposite direction. Shorter and shorter courses, shorter and shorter degree programs. The latest proposal in England have the undergraduate, not the postgraduate undergraduate degree like our 2-year degree, but the first undergraduate degree in 2 years. Stuffing people full with information as quickly as we can, all in the name of efficiency. This is not just cultural barbarism, it is criminally stupid. Because everything you can teach in that sort of environment will be the things you can teach faster and cheaper to a machine. You are preparing people to compete exactly where we as humans are the worst in competing. We should move exactly in the opposite direction, not giving in a 10-week course already after 5 weeks feedback, so that students feel that they should have understood everything already after 5 weeks. Rather than telling them, you won't understand everything, or even the majority even after this course. Maybe in a year's time, maybe in 2 years' time. It will come to you. But for that, you need a mental preparedness. You need a specific mindset that allows you to be open to that insight. Everything that we do at the moment in terms of education reform forces us to be more like robots than ever before. And robots are better at being robots than humans will ever be. So if we want to teach creativity, all the research that we have done in my department show that that would be the most lethal way we can do if we want to prepare our students for the future. Move 37. That was a move where Alphago won the game against the human. The first reaction was, that's a very strange move. I thought it was a mistake. And Alphago had calculated a 1 in 10,000 chance that a human would make that move. So here Alphago displayed creativity by doing something utterly and totally unexpected, quantifiably unexpected. That type of creativity is also something that we can model on computers for the law. Again, a project that we did in the Joseph Bell Center. We found that a typical source of mistake in crime investigations is that police officers are not creative enough, that they settle very early on the usual suspects, on the stereotypical, the standard, the rule-based solution, but we're overlooking unusual explanations and as a result making mistakes. So we developed a system that most of the time gave the wrong answers, statistically provably the wrong answers. It was supposed to throw bizarre, outlandish, far-out ideas at the investigators to enable that Gestalt switch, to force them to think outside the box. So sometimes being willing to make mistakes, taking risks, like Alphago did, the willingness to say, this is so unusual, this should be wrong, but it might just work, was one of the examples where the computer was finally able to beat the human. And again, as pedagogues, as teachers, do we teach our students that? Do we really allow them to take risks? Do we tell them this was a totally outside argument, chance, weird idea, but that might sometimes work? I don't think we do. And again, I think the way we examine increasingly, the way we make quality assurance both of teaching and of the outcomes of teaching essentially forces us to be even worse than the best of computers when it comes to creativity. Computers can mimic human creativity by sometimes taking these statistical risks, and we've shown how this can work in crime investigations. We force our students away from that willingness to take risks. None of our students would have taken a 1 in 10,000 chance that they get a pass mark in an essay. I'm reasonably certain. That was the past. These were systems we have developed in the past. I will say a little bit about the future and the work we are currently taking out and pushing that further. In law, we find two types of discretion. We find the notion of discretion that is ultimately resolvable in just an accident, the Dworkinian discretion, Hercules. If only we had all the data, if only we knew all the facts, if only we knew all the precedents, we would come to the one right solution. If you think of law like that, then you're in trouble, because my people will be better at that. We will be better at knowing all the cases and finding them. We will be better at remembering all the principles. We will even have the flexibility to apply them, because we are getting better than that. So if you think that if only you had enough information, you would be perfect in law, then you have a trouble. If you have a more Kelsenian or maybe even a Hartian view that says there are hard cases that can't be reduced, that can't be resolved regardless of how much additional information I bring to the task, then life might be slightly different. Then there might be something irreducibly human that can't simply be designed away through an information retrieval system or an AI. And for that, I think traditional legal AI has been traditionally Dworkinian, the notion that if only we make our database bigger, if only we make the rule base bigger, then we will create certainty. But I think that we can look at other forms of creativity and computer creativity to find a different sense of legal AI. Some of the oldest creative art or creative algorithms are remarkably old. In 1797, Nicholas Simrock published a book to compose 45 trillion different waltzes, understanding nothing about music. So just using an algorithm, just using a piece of software, we would call it today, he was able to create 5 trillion different waltzes. And if you think, well, that's waltzes. I mean, who cares about waltzes? That's trivial. Everyone can do waltzes and trivial. But though actually even highly developed art can be replicated by an algorithm. In 1830, the art of composing Scottish dances without being musical. Sometimes I think not being musical is actually a precondition of being good at Scottish dancing, and I shouldn't have said that. But here we can see the power of algorithms in a totally different field, where it comes to music, where it comes to creativity. And they are actually quite old. And increasingly, obviously, we can implement them in computers and create computational creativity. But using simply randomness is one of the cheapest ways. These two systems just use a coin toss, or a toss of the dice to compose. That is cheating almost. That's the cheapest form of creativity, and yet it might be able to replicate some of the legal decision making. That's not done at the moment, and one of the research projects we are having is, can we build legal AIs that are using randomness deliberately, explicitly? There are reasons for that. Throwing dice can reduce complexity. That is Duxbury's argument. It's not normally done, but it could sometimes mean that randomness is good. If you think about the theory of evolution, it is efficient as a problem solver because it combines randomness, mutations, with rules, natural selection. So one of the most efficient problem-solving mechanisms that we have is ultimately built on making random decisions. So one of the things we are at the moment trying to find out is if there is a place for legal AI that is using randomness simply to disrupt the system, to sometimes throw something in that is not predictable and not purely by rule following. But as I said, it is in a way the least interesting way of being creative. Here's one way in which robots are sometimes depicted in law. It's a quotation from an American case. Thus, by the subtle tone of their objections, they demonstrate either that they want black judges to be robots who are totally isolated from their racial heritage and unconcerned about it, or more probably that the impartiality of a black judge can be assured only if he disavows or does not discuss the legitimacy of blacks' aspiration to full first-class citizenship in their own native land. Thus, the critical issue is what conduct by black judges will assure their impartiality. Should they be robots? Should they demean their heritage by asking for less than first-class citizenship for other blacks? We get here the same contrast with which my talk started. You want neutrality, you want impartiality, that comes at a cost. It comes at the cost of your humanity. As long as we are humans and integrated into social networks, we can't be fully impartial, and we don't want to be fully impartial. If we force this on people, we force them to be robots. That is the message that this quote from an American court gives us. And I think this is unfair both on robots and on humans. Because on the one hand, we now know that sometimes, yes, algorithms and robots can be racist. That was the racist sentencing support system that made the headlines in the US, where it turned out that an algorithmic-driven computer system that predicted reoffending was actually perpetuating racial stereotypes in a quite massive way. But it is also unfair about robots in another way, because robots are getting better at being creative or embedded in that way. That is a painting by The Painting Fool, designed by Simon Colton, who I think is the most original thinker in terms of computational creativity. This is painted by a robot. And what is interesting about it is not just that it was painted by a robot, but it was painted by a robot that was reading newspapers. So The Painting Fool uses a certain degree of randomness. It decides at random what newspaper to read. One day it might decide to read The Guardian, and it might focus on the news section. And as a result, it develops a certain attitude for that day. It feels more liberal and more negative about the world. Everything is going to the dogs. There are terrible wars going on. There's bloodshed everywhere. And it is that environment, that background, that then is transferred into its painting activity. That was, I think, I just had read about action in Afghanistan. So you get a very dynamic picture with lots of explosions, blood, and red colors, trying to reflect this mood that it had acquired. And at the same time, if it reads something about, country and garden, and how beautifully the latest generation of primrose is coming along, it will paint something much, much more pleasant and uplifting. So for us, or for me at the moment, the big question is, and of course I would have to finish my inaugural lecture with a hat tip to Neil McCormick. How could I not? How in a pluralist society, where we cherish pluralism, where we think it is important that people who have different life experiences, who come from different circles, nonetheless interact and find that level of interaction, maybe we should build AIs that do not even try to be impartial in that perverse sense, disconnected, just following the rules. There's a different type of impartiality that is not necessarily at conflict with fairness and justice. Just being human and being professional and good as a human judge. And increasingly, in creative AI, we are getting there. Something that hasn't been tried, but which we will try here in Edinburgh over the next couple of years, is to ask, can we and should we build legal AI that is decisively feminine or masculine, black or Caucasian, poor or rich? Will that make a difference about the way these systems are work and the way they are used? So in the spirit of legal pluralism, I didn't quite finish with him because I wanted to also finish on a slightly more uplifting note. Move 78. That was a move when the human Go master was finally able to beat the machine again. It took me by surprise. I'm sure that would take most opponents by surprise. I think it took Alphago by surprise. So from its experience playing against Alphago, the human player suddenly developed solutions that were even more outlandish, even more strange, even more unlikely than that what the machine had thrown initially at it. And God's touch, it was called. And since we started with God, finishing with God in a sense is also, I think, quite appropriate. And there was, again, according to Alphago, a 1 in 10,000 chance that that move was successful. The lesson from that is that some of the doomsayers are probably mistaken. They take the present and they extrapolate it, keeping everything the same, but only changing the presence of AI. That won't happen. We will change as we interact with these machines. We will also raise to our game. We will get better. We will improve of it, and maybe find different ways of being creative. Teaching students about computing is part of that. And I'm very glad that Edinburgh is taking this serious, and we will have discussion with the head of school upon my return from my sabbatical. How we can do much, much more about this and introduce proper Python teaching and data mining into the undergraduate, postgraduate, and diploma curriculum. But I do think they are only part of it. Teaching students computing skills can only be a small fraction of the task that we are facing. What we need to teach them is this ability to raise to their game, and they are confronted with machines that know more and are faster. And that requires creativity, patience, empathy, spontaneity, ways of thinking that transcend what we are doing by now. As I said, I'm worried that pretty much all teaching reform proposals try to force us in the opposite direction. I'm extremely glad that Scotland has resisted the worst of it by still keeping education free, by resisting accelerated 2-year nothing but teaching degrees so far in the legal profession. We are, I think, better placed than many, many other places to make that a reality and to resist the takeover of the machines. But the AI is far enough to make this a real concern. So to conclude my talk, if AI Sedol hadn't played those, he would not have found God's touch. We should teach our students to find God's touch, to be open, to be perceptive, to come up with ideas that we wouldn't dream about as their educators. And therefore, don't worry. The end. Thank you.